20 years in prison for a poet, 20 years for the editor of a magazine, and in the entire ruling, listen carefully to this, there is no weapon, no injury, no dead body. There are 2 typewriters
and a library, which in this case file counts as evidence for the prosecution. Let's read it carefully because this ruling collapses on its own, paragraph by paragraph.
I'm Tatiana, and this is the legal podcast of the Cuban Observatory for Human Rights, the OCDH. In every episode, we take a real ruling against a Cuban political prisoner and analyze it for what it is, a judicial document that can be examined.
And I'm David, a lawyer. My job here is to take the text the court signed and hold it up against the international standards Cuba committed to respect. No embellishment and nothing invented.
Today, ruling number 4 of 2003, Provincial People's Court of the City of Havana, 2nd Criminal Division, sitting as the Chamber for Crimes Against State Security.
Notice that detail before we go on. A chamber specialized in crimes against state security is not a court resolving a dispute between 2 parties. It is a body whose declared function is to protect those in power.
The defendants: Ricardo González Alfonso, 53 years old, a journalist, editor of the magazine De Cuba, and Raúl Rivero Castañeda, 57 years old, a poet and journalist, founder of the Cuba Press news agency.
2 names anyone who has followed Cuban journalism will recognize. The ruling, however, describes both of them as, and I quote, unemployed. Writing for this court is not an occupation.
The charge acts against the independence or territorial integrity of the state, Article 91 of the Criminal Code. The sentence, 20 years of imprisonment for each of them.
20 years. To grasp the scale, under Cuba's own criminal code, 20 years is the range for homicide. Here there isn't so much as a scratch anywhere in the proven facts.
David, tell me exactly what the court says these 2 men did.
Let me summarize, and you'll realize right away what you're hearing. That in 1990 they called themselves independent journalists. That in 1995 they created the Cuba Press agency.
Go on.
That in the year 2000 they founded the Manuel Marquez Sterling Society of Independent Journalists, and out of it came the magazine De Cuba. That González Alfonso set up a library in his home with, and I quote literally, a large quantity of subversive books.
In other words, he owned books.
He owned books. And it continues that they published in CubaNet, in Encuentro en la Red, in the Miami newspaper El Nuevo Herald, that they worked with Reporters Without Borders and with Agence France Presse, that they sent material to Radio Marti, and that they were paid for their articles.
That's a professional resume, David. You are literally reading out a resume.
Exactly. And that's the core legal problem. The court does not describe criminal conduct and then classify it. It describes a journalistic career and puts the name of the gravest crime against the state on top of it.
It also adds the visits to the United States interests section, 14 times for one of them, 5 for the other.
And talking to foreign diplomats is not a crime in any democratic legal system. Article 19 of the International Covenant on Civil and Political Rights protects the right to seek and receive information, and it says it in these words, regardless of frontiers.
There's an almost domestic detail that struck me. The court mentions that González Alfonso fixed up his house, put in carpets, air conditioning, and 30 plastic chairs.
30 plastic chairs. And there's the heart of the matter. The chairs were there so people could sit down. It was a meeting room. The court lists them as evidence of guilt because what really bothers it is that people were gathering.
Let's talk about the evidence. What led the court to treat all of that as proven?
6 witnesses, all 6 of them neighbors. And what they testified was this, that they saw cars with diplomatic plates, that they saw a lot of people coming and going, up to 15 or 20 at a time, and that they saw packages, briefcases, and envelopes being delivered.
Is that it?
That's the substance of it. Not one of them testified about a criminal act. They testified about the social life of 2 houses. People coming and going from a home does not prove an attack on a country's territorial integrity. It proves there was associative life there.
It's neighborhood surveillance turned into criminal evidence.
That is the exact definition. And there's more. The court says it weighed the report of the police investigator and calls it, I quote, extremely illuminating. The officer who investigated the case ends up being the judge's main source of conviction.
And the defense?
The defense takes up one line, a single line, saying it confirmed its provisional conclusions as final. Not one argument recorded, not one piece of exculpatory evidence, not one objection. And there was a single court-appointed lawyer for both defendants, appointed, not chosen by them.
The covenant requires effective defense and a lawyer of one's own choosing.
Article 14, paragraph 3. Here there is neither, and both men came to trial in pretrial detention without the ruling explaining why. Zero reasoning, no flight risk, no destruction of evidence, and note that the evidence had already been seized in the searches.
Article 9 of the covenant says pretrial detention must not be the general rule.
And here it was, with no reasoning at all. A deprivation of liberty that is not reasoned is, in the terms of Article 9 itself, arbitrary detention. That is not my opinion. That is the standard.
Let's go to the legal heart of the case. Article 91. What does it actually punish?
It is designed for treason and external aggression, for someone acting on behalf of a foreign power against the country's independence or its territory. It is the high treason provision.
And what did they fit inside that provision?
Founding a news agency, which is freedom of the press. Setting up a society of journalists, which is freedom of association, Article 22. Gathering people at home, which is peaceful assembly, Article 21. And owning a library, which is freedom of information.
4 fundamental rights turned into an act of treason.
And there is one paragraph where the court tries to explain the causal link and gives itself away. It says those writings were supplied to the United States to be used against the Cuban people internationally, I quote, to the detriment of our independence and the integrity of our territory.
Translated, what does that mean?
It means there is nothing there. Not one act by a foreign state is identified. No loss of territory, no concrete harm to independence. All there is damage to an image, reputational harm to the government punished under the treason provision.
The court insists a great deal that they published false news.
It insists, and it does not check a single article, not one. It declares the information false without examining it. And remember what year we are in, 2003, Cuba coming out of the special period. Hunger, blackouts, scarcity, reporting that was not distorting reality, it was describing it.
Let's talk about the aggravating circumstances, because there is something incredible there.
There are 6 subsections of Article 53, and each one makes the picture worse instead of justifying it. The first having been part of an organized group. The sentence is increased precisely because of what Article 22 protects, which is the right to associate.
And the court adds that those organizations were not authorized by the Ministry of Justice.
That is the perfect circle, and it needs to be said slowly. The state does not register you, and then it convicts you for operating without registration. It shuts the door on you, and then punishes you for coming through the window, 20 years.
The second aggravating factor is financial gain.
And here the ruling flatly contradicts itself. The court itself threw out the prosecution's evidence on bank accounts, and it says so in these words, for contributing nothing whatsoever to the proceedings.
It throws out the financial evidence and keeps the financial motive.
It throws it out and still holds on to greed as an aggravating factor and as the driving motive behind the sentence. A court cannot discard the evidence for a fact and then treat that fact as established in order to increase the punishment. That is not a technicality. It is a basic collapse of reasoning.
And there's the aggravating factor of grave consequences,
which the court defines as publishing false news about, I quote, the true reality of Cuba and its achievements. The grave consequence is the government's prestige. That is the legal interest being protected with 20 years in prison.
And another one caught my attention, the prior police warnings.
The formal warning records, which are not convictions and are not crimes. They are an administrative instrument of intimidation. The police telling you that you are being watched. Turning that pressure into a factor that increases the sentence makes the repressor's warning count as a criminal record.
And there's a line about their motives.
It says the motive was, I quote, greed and an easy life. 20 years in a Ministry of the Interior prison for seeking an easy life. By writing. In a country where writing costs you your freedom.
Twice, the court says it is guided by socialist legal conscience.
Twice. And that ends any discussion about impartiality. A judge who declares he is guided by an ideological conscience is not applying the law. He is applying a loyalty. The United Nations basic principles on the independence of the judiciary require deciding without influence or pressure of any kind.
And the language in the rest of the ruling goes the same way.
It speaks of salaried agents of the United States, of the anti-Cuban mafia in Miami, of 4 decades of aggression. That is partisan political speech, not judicial reasoning. A court that produces propaganda for the prosecution has stopped being a neutral third party.
And from the very first line of the proven facts, it calls them people who disagree with the revolutionary process.
That is the presumption of innocence inverted in the opening sentence. A political position is judged before a single fact is examined, and the court finishes by saying the punishment seeks to reintegrate them into respect for the norms of socialist coexistence.
To re-educate them ideologically.
It's a confession in writing. The stated goal is not to repair harm, because there is no harm. It is to re-educate two dissidents. That is punishment for one's convictions, and it is prohibited by Article 18 of the Covenant.
That leaves the confiscation, which takes up an enormous amount of space in the ruling.
Enormous and very revealing. 2 desktop computers, a laptop, a scanner, a printer, video and photo cameras, typewriters, tape recorders, shortwave radios, discs, cassettes, and a large quantity of books, all seized.
Everything you need in order to inform people.
Everything. These are not proceeds of a crime or illicit gains. They are the tools of the trade and access to information. That confiscation is material censorship, physically dismantling the ability to write, and seizing books because of their content violates Article 19 of the Covenant.
David, before we close, something we repeat in this series, and that applies here. In this case, there was no violence. There were articles, a magazine, and a library. Yet the court bases the sentence on the social dangerousness of those who oppose the powerful.
And that's the point. The same regime that hands down 20 years for writing came to power by armed force. The assault on the Moncada barracks on July 26, 1953, in which soldiers were killed, is a national holiday in Cuba.
It's celebrated every year.
Celebrated every year. And whoever celebrates an armed assault on a barracks while jailing a poet for 20 years for publishing articles is not applying a stricter moral standard. They are demonstrating the absence of any moral standard at all. It is not ethical superiority, it is raw power.
Let's recap the errors and abuses, the main ones.
A court that declares itself ideologically committed. The presumption of innocence inverted in the first line. A single appointed lawyer for 2 co-defendants with no trace of a defense in the text. Pretrial detention without one word of justification. A treason provision applied to founding a magazine and owning books, with no causal link whatsoever to territorial integrity. 6 neighbors who saw cars and visitors treated as evidence for the prosecution, and 20 years with no victim, no violence, and no proven harm, with aggravating factors that punish rights, associating, assembling, being paid to write.
This is not an isolated case, it's a machine.
It is a machine, and it is still running. The Cuban Observatory for Human Rights documents at least 760 political prisoners in Cuba today. This ruling, more than 20 years old, explains exactly how each one of them is manufactured.
Let's close, David. In one sentence.
Ruling 4 of 2003 does not document a crime. It documents a newsroom, a poet, a journalist, their typewriters, their magazine, and their library, and 20 years in prison for all of it.
In terms of international human rights law, this is not a criminal sentence. It is an act of repression in the shape of a court ruling.
And that is why we read them out loud. Because these documents were written to sit in an archive, and an archive is exactly where impunity is best preserved.
This has been the legal podcast of the Cuban Observatory for Human Rights. All the documentation, the reports, and the list of political prisoners are at observacuba.org.
We'll see you at the next case file. Thank you for listening.